next matter to come before the court this morning, or this afternoon, excuse me, is Joel Helms versus City of Akron Department of Neighborhood Assistance. Both sides will have 15 minutes to present an oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you let me know when you get started, I'm keeping track of the clock, but you can also reference it on the wall over there. Please don't use the names of any victims or minors. I don't think it's relevant, but we like to make that admonishment as these are being recorded and will be placed on the court's YouTube channel. Please introduce yourself and remain behind the podium, as I did just indicate these are being recorded. The judges have read your briefs. We're ready to proceed when you are.
Joel Helms, Ellen.
Would you like to reserve any time?
Yes, I would, 5 minutes.
Certainly. Go ahead.
Okay. Our first question is jurisdiction or standings. The complaint, there was no complaint or request from either the owner or occupants for a housing inspection. 150 OC seems to extend the right to a citizen to make a complaint. None exists there either. The only complaint they had was a welfare check that didn't really cite any 150 violations. Now, then we have the 8 years so far of use of the property for sanitation purposes only. By definition of the law, included in the law in 150.07, not covered by this law, if that's the only use I'm making of it. So the violations which are there could possibly be there if I were to use it for some other purpose, but right now don't exist by definition. And then there's the review of the board's minutes show that they did not schedule the meeting, the hearing. The law requires them to schedule. Had they scheduled it once they received the information from the housing board, that would give them another month to review the record. And so they were limited to what they did. So we have basically 3 items where there's no jurisdiction here. 1, no originating complaint that gives them the power. Second one, by definition, the violations aren't there. And third, obviously, there's no jurisdiction of the hearing board. Then we come to Helms, which they've hung their primary argument on, is Helms is shown as the tax address on the land records, on the parcel bill. And with one click away on that particular page, when everybody goes to the parcel search, you see that I'm also the agent listed. And then the property name index, which was corrected during the full property owner's name index, which was corrected during the case. That was the third issue. It was where so there are 3 places in the land records of Summit County where I'm listed as an interested person, and that is the definition of who has the ability to sue or represent the property if you're listed as an interested person in the land records. The second issue is the housing board had already accepted me as an interested person. And lo and behold, at the hearing, the law department challenges that. Evidentiary rules require if they're going to challenge something that's already been accepted, and I have to submit papers to document. I can't do it with I can't be an evidence. I've got to actually have the paperwork. I have to be pre-notified. They didn't do that. And then when I asked for that through the common police court, guess what? Evidentiary rules, they weren't there. Can I please supplement? Common police wouldn't allow me to supplement, citing the normal purposes of supplementation in a common police case, or excuse me, in an administrative appeals case. But this was a pure evidentiary rule issue. So the board has documented their standards in the monthly minutes, and their standards are the old law, the original 759 law that is quite comprehensive, and they're saying those are their standards. Yes, that law has been supplanted when there was a change in Akron's organization. The new law really doesn't have any standards to it. So they have chosen, they're allowed to set policy that's not in opposition to the present law, and they have said that. They're repeatedly, in every monthly minute, you see that they set that as their standards. Well, lo and behold, there is nothing in the records to those standards that says when a house is dilapidated. So all we have in the record is Jody Foster, the agency basically declaring that it's dilapidated. It's a nuisance. Based on what grounds? There are no grounds anyplace in the record.
What's the status of the structure today? Has it been demolished or is it still in existence?
The city has, without a demolition permit, gone in and tore out all of the heating system. Now, that's not a serious issue because essentially I've applied for permits to put solar panels on the front and take off the whole front porch, which one of the two things that they were objecting to really in the process was they didn't like the front porch. I was going to tear it off. Why fix it? Type thing. And it didn't actually violate their regulations either. So they've torn the heating out. I'll be forced now to put in the new heat pump systems and things like that, which will be more economical in the long run. Also, their contractor, when he was there, I objected because he basically cleaned out most of my basement. I had a lot of stuff stored in my basement. The heating contractor, or the asbestos contractor, taped up the building, advertised it to everybody in the neighborhood, and about 2 weeks later, the homeless people burnt my garage down. So presently, where I was in the top 10% of the neighborhood in value, we know.
It confuses many people because there are 3 circles over there. The garage is burned down, so right now I'm probably, with the garage gone and the heating system gone, I'm probably at midpoint value-wise. But at the time of the hearing, there was no citizen complaint. And with the property being in the top 10, okay, 150.051D, when a dwelling can reasonably be repaired so that it no longer exists in violation of any provisions, it shall be ordered repaired. There was no evaluations made. That in itself, the board violated the law in that they didn't evaluate, was this property salvageable? Like I said, one of the 2 items that they said was bad, I had front porch and back porch. There's nothing wrong with the house. The house was totally rebuilt in the 1980s. Same with the garage. But we're going to tear the front porch off. That actually was the last place that was any lead paint on the house, which I hadn't done in the 80s because I knew I'd be tearing it off way back then. But, so there's no, well, strange is, when they came in and took the asbestos out, there was no asbestos in the house. So they took the whole system, heating system out, just because that was their contract, but there was no asbestos there. And obviously it's lead paint, I've already removed that in the front porch, partial removal, not to look like for a total eyesore in the neighborhood. I didn't want to totally tear the porch down. So basically, I guess I'm requesting this court to overturn the board's order that was without jurisdiction at any point. I had full interest in the property during the whole process, and we find that there was nothing in the hearing that justifies it being torn down, and then they lacked a mandatory thing that they had to do, they didn't do.
What was your interest in the property, not just, you say you're referenced in a tax, that you pay the taxes? Are you?
I pay the taxes as one.
Okay, but what's your ownership interest? Is there any type of ownership interest?
We have a land contract interest that was the land contract, the actual, it was never recorded, I didn't realize the lawyer didn't do it, but the land contract went to the bankruptcy court when I bought the balance of from the bankruptcy, when the person was in bankruptcy, I bought the balance, The docket of the bankruptcy shows that I own the property, although all the records from bankruptcy were destroyed after 15 years. So the other instrument that was in the land records shows that where I paid the taxes for more than 20 years. It shows where I evicted the landowner when the person that sold it to me under land contract, I actually evicted them in municipal court, which I would have actually had to have the land contract to do to that eviction because they were the owner of record. So all that records are in the other document that was filed under a provision in law that says if you have any interest in a property, you've got to file this. And they claimed, well, it's a self-serving affidavit. Well, I don't know who else could have offered that affidavit, who would have that knowledge of what took place 35 years ago. So it's not so self-serving, it's actually a required document in law.
You are just now reaching that 5 minutes to rebuttal. You can continue, or you can reserve the entire 5 minutes.
Oh, I'm done, okay, thank you. I'll reserve 5 minutes.
Certainly.
Good afternoon, Your Honors. Kirsten Smith for the City of Akron. Your Honors, in this case, the trial court correctly determined that Mr. Helms lacked standing to pursue his administrative appeal. Because he is not a legal owner of the property, he has no equitable interest in the property. And really, the only reason he's associated with this property is because at the hearing, testimony was proffered that a housing inspector went to the property located at 1117 Ackley. I believe Mr. Helms' sister was there and said that Mr. Helms was the owner, so the inspector jotted him down as an agent. However, any legitimate property record associated with this property lists Nanny Harrell, not Joel Helms, as the owner of the property. We maintained this throughout the administrative proceedings, throughout the trial court, which the trial court agreed, and now again here on appeal. This court in Antouche v. City of North Ridgeville held that a property rights must be directly affected by an administrative order in order to have standing to pursue an administrative appeal. Mr. Helms has repeatedly alleged that he is a land contract owner. However, the Summit County Fiscal Office has no record of that. He never presented it at the administrative hearing or any other document to that nature. Now, he does say he's listed as the tax agent. However, that doesn't establish an ownership interest in the property. You know, I could have an accountant pay my taxes on my home. They'd be listed as a tax agent on the website. Mr. Helms also asserts that he filed an affidavit with the Summit County Recorder's Office stating that he is the registered owner agent of the property. Mr. Helms filed that one day after the trial court affirmed the demolition order. It was not before the trial court, and he cannot raise that for the first time on appeal here. I'm not going to get into, the merits of what that affidavit means because it's not on the record. It's never been considered by anybody, really.
Is the house still standing, or has the city demolished the structure?
The house is still standing. As Mr. Helms indicated, the garage did burn down. The only reason it's still standing is because there's a backlog of demolitions that need to happen in the city of Akron here.
What about is there a partial demolition though? Has something happened there at all? City, I mean?
The city filed an affidavit of condemnation to begin emptying the property, as Mr. Helms indicated. But there's really only so much we can do without, the bulldozer and the contractor to be able to actually demolish. So there has been some emptying of the property, but the structure is still standing today. So we believe Mr. Helms does not have standing in this case. Should this court determine that, the trial court still correctly affirmed the order of the Housing Appeals Board demolishing the property. This property came before the board after 3 years of non-compliance with repair orders. Things like the property needs a roof replacement, the gutters on the property are missing, broken and boarded windows, damaged siding, and the porch was in disrepair. The inspector was not able to enter the inside of the house, someone prevented them from doing so. So these are just what we know, what's on the outside for these repairs. In addition, the standard of review on appeal for these strongly favors affirmance and only permits reversal where the trial court errs in its application of the law or the decision is not supported by the preponderance of the evidence. So if there are no further questions, I would ask the court to affirm the decision of the trial court and overrule Mr. Helms' silence of error.
Thank you. Mr. Helms, you have 5 minutes for rebuttal.
Joel Helms again. Royalston is one thing. Our code in Akron is specific who has an interest that can speak on the appeals board. Obviously, if you're able to defend it at the appeals board, you also have the right to appeal it. Ownership is not required. It's very specific. And interest as shown by the land records. 2 things were shown previous to the case. Obviously, I was the agent, which is a required documentation required by Ohio law. If you don't live in the house, you must register your name with who is in charge of the property, with the records. That's a state requirement. The second issue is, obviously, who's paying the taxes? Obviously, if I wasn't on there paying the taxes, this place would have been under foreclosure, who knows, 30 years ago, or it would have never been bought out of bankruptcy, whatever. The records show that I'm the mailing address, and then if you actually look at the records and accumulate all the records, I've been actually paying all the taxes. It's not that I'm not just an agent receiving the mail and giving it to someone else. I've shown, and their records will show, it's their records are what I submitted to that other common pleas court case. It was transferred to the municipal court, so it was never processed. But those records that was already submitted to that court showed from the, here's records that they have showing I paid the taxes. So the indexing, that was a mistake. Obviously, that was corrected. But standings, actually for standings in any case, can be corrected at any point in the trial. So, but we're not depending upon that third item, the index, that the index was not properly filed. Originally it was only filed with her last name, not her first and last name, so it was not indexed by the recorder's office. The paperwork was there, but it was not indexed, so you would have to do a Helms search to find it. The affidavit of condemnation. Yes, they have an affidavit of condemnation that I basically filed an affidavit challenging that half the stuff in there is incorrect. Like the board had the hearing. I filed, the board never scheduled a hearing. There was multiple things in that affidavit of condemnation that were incorrect. And I would challenge that they could get, based on my affidavit, if they could get a demolition permit to tear the house down. Obviously, they've already started the demolition process without any permits. I'm supposed to be given a 10-day notice when the demolition starts. They don't do that. That's by law. And then also the law provides that this is state law. If a city has any law like this, there must be a provision to correct the deficiencies. They have nothing in their law, and their general practice does not, once they condemned it, I could not take a permit out to fix that porch, to finish that porch. It was both an electrical permit because it's solar panels and a construction permit, which I'm licensed in both. I could not do that work to finish it up. By state law, I must be allowed to do so, and they basically don't allow it. I guess I would further ask, because of that issue, this court has found that, or questioned that if I could get a stay in this, I believe there's federal issues here that are very important. I would appreciate this court, if it were to rule against me, to offer me a stay until I can get this resolved in federal court, that they take rights away from me first of all, where they have no jurisdiction to begin with, in multiple ways, where they've showed no evidence in law, where they've actually violated the law in not, they shall order to repair, they've not done that. So they violated the law, and everything about this thing is, you've got 9 things here that you actually could overturn this on. I would, and if you would, for any reason, not to overturn it on any one of these, I would appreciate a stay in this issue. Obviously, I've twice applied to the town police board, and they did, I'm totally ignored. So, I do thank you very much. Please overturn the board's decision. Thank you.
Thank you both for your presentations today. The court will take the matter under advisement and will issue a decision which will be mailed to all parties to this appeal by the clerk of courts on the day that the opinion is issued. It will also be posted on the Ohio Supreme Court website. Thank you. We are now adjourned.